Okay, very good. The defendants are present, defense counsel is present, the state is present, and I need to get my glasses because I can't see until I have my glasses, okay? So I'll be right back. No, they're in the office there, either on the desk or in my purse on the interior pocket. Thanks. I set him down, then I'm like, yeah, I can't see. Okay. So I have reviewed the following motions. Isaiah Chance has a motion in limine, and the state filed a motion to compel disclosure of raw data generated during administration of tests for a number of the defendants. And then Rashad Murphy filed a defendant 6 motion in limine as to Robert Howard. Are there any other motions that we need to hear today, other than those 3?
Judge, I believe Mr. Harmon filed yesterday a motion for order in limine having to do with the verdict of Alicia Andrews. Did you receive that?
I don't believe that I did.
It was filed yesterday.
I thought we discussed that already, but
We did briefly, Judge, and I think that's why Mr. Harmon filed the motion.
okay. Yeah, and I indicated that it was certainly not relevant during guilt phase.
And so this has to do with penalty phase.
Okay, well, I don't know. So, all right, I haven't reviewed it yet, so I'll take a chance and take a look at it. Take a second and look at it after we do these. Okay, y'all care which ones we start with?
Judge, I think Ms. Isburn was hopeful that we could do Mr. Howard's motion in limine last.
Okay, sure. All right, so why don't we start with the state's motion to compel disclosure of raw data generated during administration of tests. And I have a motion filed as to Rashad Murphy, Davion Murphy, and Isaiah Chance.
Very, very quickly, just for the record, Christopher Delauder is going to be sitting in. He is a certified second phase attorney. He wants to get some experience on first phase, so he will be sitting in with myself.
For the remainder of the trial, or just today?
That's correct. As much as he can. I don't really
Sure.
I
That's
just
fine.
want the court to be aware of that.
Yes, thank you. Good morning. Okay, so those are the 3 defendants. Did Mr. Gathright, do you have one as to Mr. Gathright or no?
No, Judge, these were, it's my understanding from Mr. Harmon, these were the only 3 defendants that had mental health experts in this area.
Okay, so Mr. Gonzalez, as to Rashad Murphy, do you object?
Judge, I think that would be a...
Oh, I'm sorry, Mr. Hernandez, do you
I'm sorry,
object?
what motion is this, Your Honor?
It's the state's motion to compel disclosure of raw data generated during administration of
No,
tests.
Your Honor. Obviously, that is done directly from one doctor to the other. We don't get involved in it, but I can contact my doctor and it gets sent directly to the state's doctor.
Okay, and obviously, and I don't know, only you know, in the raw data, your expert may know, if there's anything in there where the defendant spoke about the facts of the case or defense strategy, then obviously that data does not have to be disclosed to the state.
I would have to check with the doctor, but based on the deposition that was taken last week, I think that that's not going to be an issue because in response to one of the questions, my doctor indicated that the defendant had not discussed whether any issues regarding guilt or innocence. So I don't think that's an issue, but I would have to double check with the doctor.
Okay, well, just make sure that they know before the data is conveyed to the state that if there is anything in there that that can be redacted or withheld, but you just need to, essentially, what I would need the doctor or you to do is to make some type of privilege log, just so it's reflected that this is what we held back and this is why. And then if there is a finding of guilt as to first-degree murder, and if we're going into a penalty phase, then potentially that material would have to be disclosed, but we can discuss that if we get there.
If once the state can provide me an email for the doctor, I will reach out to my doctor to have it send with the court's instructions.
Okay?
That's fine, Judge.
Okay, very good. All right, so as to Mr. Sonardi, as to Davion Murphy, do you object to the motion?
Yes.
Or, go ahead.
Yes, correct. To the state's motion you're referencing?
Yes.
Yes,
Okay, just, you don't think any raw data should be, at this point, disclosed?
correct,
Based upon what?
correct.
No, what is your argument? What's it based upon?
I'll just adopt the other co-defendant's arguments as to that.
Okay. Okay, so I'm gonna grant the motion with the same exceptions. Mr. Sonardi, you just need to confirm with your expert that they are to supply the raw data you get the information regarding the state's expert. However, if during the interview of Mr. Davion Murphy, if he made any statements regarding the facts of this case or any defense strategy, then those statements or that data does not have to be transmitted, but you do have to create a privilege log if you're holding it back. Okay? All right, and finally, as to Mr. Isaiah Chance, Mr. Petratus.
Good morning, Your Honor. We would object, I spoke to our doctor, and her concern was that the state's doctor is a psychiatrist, not a psychologist, would not have been trained in the test that she administered, specifically to Mr. Chance, based on that conclusion.
Okay, well, that sounds like a jury issue, potentially, cross-examination or direct examination issue. So I'm gonna grant the motion. Again, Mr. Petratus, the same thing. If there is anything contained in the raw data regarding defendant statements as to the facts of this case or as to any defense strategy, that does not need to be conveyed to the state's expert, but you would need to create a privilege log. Okay? All right, very good. All right, so Mr. Chance's motion in limine, and state, do you object to this motion?
Yes, Your Honor, the state this morning filed a response with its motion limine. It was filed yesterday, provided courtesy copies via email to the court, and provided physical copies to the defense attorneys as well as the courtesy email this morning. We included the argument from Mr. Petratus as well as the argument on behalf of Davion Murphy for the YouTube videos that were listed. Mr. Petratus filed.
Well, this is all I've got. This is all I've got. Mr. Chance filed a motion in limine and wishes to have excluded any allegation, mention, inference, or indication, whether through witness testimony, picture, video, or attorney statements to the jury of music video or stills from the video, quote, "Blood on my Pradas," close quote, by Isaiah Chance. Said video has no direct connection to the murder of Charles Jones and has imagery, firearms, dead body, etc., that would be unduly prejudicial without any probative values. That's what I'm referring to.
Yes, Your Honor.
Okay, so you're objecting to that?
Yes, Your Honor.
And what's the basis of the objection?
The evidence, there is items or are items of evidentiary value contained within that YouTube video presented at the state's evidence view. The state did decide to utilize screenshots in lieu of the video itself. Those screenshots depict the defendant only, not the dead bodies in his videos, and all of the violence from the videos. We actually limited the exhibit itself to several screenshots, well, many of which prove up elements that are required for the gang enhancement.
Okay. And what's your response to that, Mr. Petratus?
Judge, not withdrawing my previous objection to the gang.
Right.
But if it's just photos of him with I assume the 23 chain, stuff like.
Do you have the still shots here?
Yes, I presented the still shots we used at trial at the evidence view to defense.
Okay.
I have them electronically as well on my computer, Your Honor. I can pull them up if necessary.
I have the 3 photos, I believe. 2 of them just Mr. Chance with a 23 chain. There's no other imagery that we would object to. The other issue is though, the name of the video is one of the pictures, and I would
your response to that?
The state, in admitting the evidence, is proving the authentication of the video and the source from which the video derives. So, identification of the defendant, number one, given that the subscriber information records linked to this defendant, the title that's used or the name that is used by the defendant is not his legal name. So it's more than just authenticating the video, but also identifying the defendant for purposes of this exhibit.
Okay, for record purposes, we probably need to identify exactly what it is we're talking about. Can you either display it so I can see it and Mr. Petratus can see it, or you can?
Yes, Your Honor.
Also, while you're doing that, we had a superseding indictment, correct?
Judge, that is correct. The only thing that has changed is count 2, which is the conspiracy count. We expanded the time frame of the conspiracy back to June 6th of 2024. That's the only change to the indictment.
Okay, Mr. Gonzalez, on behalf of Rashad Murphy, how does your client plead?
We would plead not guilty, Your Honor.
Okay, Mr. Sonardi, on behalf of Davion Murphy, how does your client plead?
Plead not guilty.
All right, Mr. Wise, on behalf of Mr. Gathright, how does your client plead?
Not guilty.
All right, and finally, Mr. Petratus, on behalf of Mr. Chance, how does your client plead?
Not guilty.
Okay, very good, thank you. All right, and while we're waiting on Ms. Ismer, let's just talk a little bit about jury selection, okay? So, well, I spoke with jury services, and they're summoning enough people, they hope, to at least get 150 in here, okay, 150 people. Actually, let me back up. We're not doing jury selection in this courtroom, okay? So we're doing it in courtroom 1. So we have just because I'm gonna need to be able to utilize the lobby outside to seat people, and there's no lobby outside of this courtroom that would be large enough to accommodate 150 people. So we're gonna do all of the jury selection in courtroom 1. We're gonna try the case in here, all right? So, I know we can get 150 in the audience on the benches. My bailiffs also determined that we could get an additional 25 in the jury box with some chairs in front. So conceivably, if 175 people show up, we can get 175 in courtroom 1. My inclination is if we have the space and we have the people, we should just bring them in. So that's my initial thought on that, is that it actually would be 175 people, assuming we get 175, Wednesday, Thursday, Friday. So then my question to you all is, as far as numbering them, my inclination is to do 1 through 150, like normal, like what I normally do in the audience, in the benches, and then do 151 through 175 would be on the side where the jury box is. And remind me, Ron, Reggie, how many chairs do we have to put in the front?
In the jury box?
Yeah, outside the jury box.
7, 6, 6, 6.
Okay, so what I will do is, I will have my JA come up with just a general seating chart, so you know the numbers of where the people are gonna be, all right? And then, starting the next day, then, we would start with 176, put 150 out there, and then if we get the extra 25, again, put them on the side, and the same thing with Friday. All right, so I will do seating charts for you all with that anticipation, and you can at least use that. Okay, Mr. Hernandez?
Your Honor, obviously with the heavily involved in the length of the trial, I suspect a lot of individual work on it. How do you plan to do
So
that?
this is what we do. With regards to this first round, and I think we discussed this before, but you may not have been here with Mr. Hernandez. So how this is going to work is phase 1 is with the jurors about hardship and whether or not they can serve, and then pretrial publicity. So what I'll do is, when we get the list of 175 names, all you all are to do is simply write down the name and the number. That's it. Don't start looking at slips. We're just get down the name and the number. I will give my introductory speech that I do in all death penalty cases. Plus, I normally don't instruct them on the death penalty at this phase. However, in this case, I am going to give a preliminary instruction because, unlike my normal practice, I am going to break down the people that can serve into smaller groups for death penalty voir dire. And the initial instruction on those jurors normally takes a while because I know I have a long speech I have to give. The state normally gives a relatively long speech, and then the defendants can give whatever speech they would like to. And I don't want to have to repeat that every morning during voir dire of the penalty phase, which would be phase 2, because it just sucks up time. So I'm going to give my preliminary instruction on the death penalty. I will then allow the state to give a preliminary instruction. You all can give a preliminary statement if you wish. And then what I will do is I will then ask the jurors 2 separate questions. I'm going to ask them first to raise their hand if they're going to claim a hardship for while they cannot serve. And then I'm going to read a statement, and I need to get an agreed to factual basis from you all to read to the jury and ask them if they think they know anything about this case. I will probably, so for those individuals that raise their hand as to knowledge about the case, pre-trial publicity, I will do individual voir dire, and we'll do that first. We'll bring them in one at a time. For those that are claiming a hardship without pretrial publicity, I will do those in groups. So I'll bring them in, probably have enough to seat in the first row of the audience, and then I will ask them the initial question as far as what their purported hardship is, and then I will allow each of you, if you wish, to do any follow-up questions. And then once all of those individuals have been questioned, then we will determine who can be excused. And at the outset, just so you know, I will excuse people for cause at mostly at lunchtime and at the end of the day, but only if everyone agrees. So if anyone objects, either the state or any of the defendants, to any of the prospective jurors being excused for cause at that juncture, I'm going to leave the person in the pool. So, because you may want to rehabilitate them, I don't know, okay? So the individuals who do not raise their hand at all, who don't know anything about the case, and who are not claiming a hardship, they will be excused until Monday. And then they will come back to begin the first smaller group for death penalty questioning, which is phase 2. So my goal is to hopefully have smaller panels of 30 to 40 people just for death penalty voir dire the following week, which would be Monday through Friday. And then once that is finished, then the following week, Monday and Tuesday, will be general voir dire for those that remain. All right? So I am well aware of the number of peremptories, 40 total for defense, 40 for the state. So I'm hopeful that we will have, at least 150 come back for the final phase. We'll see. So this is just going to be a situation where as we go along, we will see how things are going. All right? So then if I get, let's say, more than 30 people who can come back the week 2, I'll push some to Tuesday. And then same thing, Thursday people will come back either Tuesday, Wednesday. Friday people that come back will come back Thursday or Friday. I won't know until I know what the numbers are, exactly what day they're going to come back. But just so you all know, it will be smaller panels, week 2, 30 to 40, just on death penalty. Okay? So, Mr. Hernandez, is that a long-winded way of answering your question? Okay.
Judge, one question I have.
Sure.
statement that the court's gonna allow defense and state to make after your initial inquiries, what is the court anticipating with regard to that statement?
I'm assuming it's just pretty generic, just enough to trigger their memories. And we had a statement in the Alicia Andrews case that you all may or may not agree to, but it's kind of just basic parameters, things like that this was a shooting that occurred up near USF on the date in question, and that it involved an allegation of potential gang involvement, and the victim was Charles Jones, known by his rapper name Julio Foolio, something like that.
And that's the statement that's going to be given by the court?
Correct.
What about the statement that you're referring to, that you would allow both the state and defendant?
That is the statement. No. The statement
You're
that
talking about something that we are allowed to get up and do at that
Yeah,
juncture.
no. There's two separate, I guess, statements. So the first one is the one I would make in anticipation of my question about pretrial publicity, okay? The next would be with regards to the death penalty information. And again, just from experience, Mr. Harmon has a script that he uses, and I don't believe in any of the cases I've done, defense actually said anything in addition, really. So you don't have to. I'm just letting you know that if you would like to stand up and just give because I'm allowing the state the chance to do it, to give a general instruction or information about death penalty qualification.
Fine, Judge, I need some clarity on that.
Yeah, it's just, I don't think any defense attorney has ever done it, and you don't have to. I'm just giving you the opportunity if you so wish.
Understood.
Okay, but normally between myself and Mr. Harmon, we cover pretty much everything, so. Okay. And I'm also considering, and you guys tell me if you think it's a good idea or a bad idea. Once we get our jury picked, so this would not include next week, I'm considering giving the jury Fridays off. Mr. Sonardi gave me the thumbs up. What do you guys? I'm hoping that will be some sweetener to encourage people to want to volunteer to serve, since they know they at least will get Fridays off to handle their personal affairs or do what they need to do, but you all tell me.
Certainly always a good situation with regard to getting people to want to serve, and certainly allowing lawyers to do what they do. I don't know if the state has any indication. We haven't gotten a final witness list yet, which of course no one's obligated to do.
Right.
But to the extent, would the state have any indication as to what they think their case in chief, short of catastrophe, might take? I'm just more looking about, quite frankly, Judge, my calendar beyond
Sure.
May 15th. And there are some challenges there, and I didn't know whether the state has any idea as to what they might
So
do.
let me ask you this. So let's just talk about this a little bit. So hopefully, if everything goes smoothly, jury selection will be concluded by Tuesday, April 21st. Okay, that's my goal. I will be working very hard towards that goal. That means we do opening statements on the 22nd and begin with the presentation of the evidence, the 22nd and the 23rd. I can tell you right now, we will not have court on the 24th of April. So then the guilt phase portion would begin again April 27th, and we'd go through that week. And then depending upon things, and depending upon if there's a finding of guilt as to first-degree murder, penalty phase would begin May 4th or thereabouts, and last most of that week.
Does that comport potentially with what the state would anticipate from a case in chief standpoint? And again, I'm asking a question that they may not have the answer to, Judge. I'm just inquiring.
I think that in general terms it does. I know that this trial will be somewhat longer because there's more attorneys
So I'm trying to remember how many days did it take us in the Andrews case? 7? Well, remember we picked a jury though.
Correct.
Starting, I can't remember, did we start Wednesday or Monday? I think it was Monday. Did we start Monday?
Judge, I don't remember.
Yeah, I don't.
I'll have to go back and
don't
look.
either. Let me look. I don't know. What month even was that? Who could even?
It came in on October, on Halloween.
Okay, let me look.
5 years ago now?
Yeah, it feels like it.
Halloween night.
Yes, it was. Yes, it was. Okay, well, I don't have that with me. So anyway,
That gives me a much better indication, Judge, without nailing anybody down, that actually answers my inquiry, truthfully.
yeah, it took us a couple days to pick the jury in that case. It took, 2 to 3 days to get the jury picked. So it took us, I'm gonna say, about 7 work days to get it tried. So maybe 8 or 9, just because we have more lawyers, but I would say 8 or 9 for guilt phase portion of the trial.
And there may be a few more witnesses in this case.
Okay, okay.
And probably a little more extensive testimony from those witnesses, because I think there were some limitations.
Sure.
In the Andrews case that probably don't exist here.
Sure. Okay. So, yes.
I guess along those lines, I think it's safe to say that I should, if there is a need for a penalty phase, I shouldn't have any witnesses ready in April. It should be May.
Yeah, it'd be May. I would say May 4th at the earliest. May 4th at the earliest. And I'm going to ask Mr. Hernandez, what's your absolute need to be done by date? Mr. Gonzalez, what's your absolute, and Mr. Hernandez, what's your absolute need to be done by date?
Judge, preferably the 18th or 19th of May. I don't know whether any of those days fall on the weekend, but.
Yeah, we'll be done by then. Okay? Mr. Sonardi, what about you? Any?
Fine.
Okay? Mr. Wise?
Your Honor, my only, sounds like, I'm on the same boat as Mr. Gonzalez. I had everything blocked off for May 15th, so starting May 18th, I have.
Yeah, we'll be done by then. We'll be done by May 15th. Okay, we will. And Ms. Petratus? Okay, yeah, we will. So, okay. Very good. So now that we've discussed the calendar, so at this point, I won't commit to the jury taking Fridays off. I will tell them Friday, April 24th for sure, and that if we're making good progress and it looks like I can give them a Friday off, then I will. But at this point, I'm going to be conservative because it's more important that we, the trial gets completed in a timely fashion. So, okay. Okay, Ms. Ismer. Yep.
Yeah, the signature, can we pass these out to these guys, or that's, what it looks like? And Connie made the
Yeah.
sheet in the back. Want me to just make a copy and give it to
That'd be
them?
great.
Okay.
Excellent. Okay, so this would be, the state is displaying, this is a still shot, blood on my Pradas, and that is Goudaze, which I believe is a name that Mr. Chance goes by, correct?
Yes, Your Honor.
Okay, and when was this distributed, or?
I'd have to look back at the original motion for the date.
Okay, or posted? September 2023?
I
Okay,
think the 8th of 2023.
okay. So this is the one you object to,
This specific
this specific
picture, Judge.
picture?
And I'll say, we're not gonna be objecting to Detective Meter or someone who knows him saying that that is Mr. Chance, and we're not gonna be objecting that is the name, the top Goudaze that he uses. But I don't, and we're not gonna be objecting to this, based on your ruling. The other two pictures, which is him wearing a 23 chain,
Okay.
shown in this picture. So I'm not gonna object to this and then
Well, yeah, so what if they just redacted blood on my Pradas?
Well, I would say that what he's doing in that picture could be interpreted negatively, whereas they're just trying to show him wearing the 23 chain in a music video. I don't want to say stipulate, but I'm not going to object to suggesting this was a video he made on September 8, 2023. That is Mr. Chance, and he's wearing, it can be very obvious in the other two pictures, a chain, the number 23 on it.
Yeah, well, it looks like, just for the record, it looks like he's maybe mimicking shooting a gun or shotgun or something. That's what he appears to be doing. So why do you need the title "Blood on My Pradas"?
All of the other exhibits from YouTube include the title and the account name for the individual who posted them. So to redact only this screenshot or only this defendant's music video, which indicates obviously still images for at least this exhibit of the defendant wearing his gang chains or talking about offenses or crimes that are linked back to the gang that he's affiliated with, I think it causes a discrepancy in what evidence is being presented. The defendant would, in this instance, be the only person whose music video title isn't also displayed alongside of all of the other videos which are establishing his gang enhancement.
All right, let me see the other still shots, just to make sure, for the record.
This is still shot 1 and still shot number 2. Both have been redacted to remove the guns or body parts that were depicted.
Okay. And this is going towards the gang enhancement, correct?
That's correct, Your Honor.
Okay.
We'll seek testimony as to the lyrics because in playing the video, obviously, we knew the defense would have an objection to all of the content, which is why we've redacted to these specific images.
Okay, very good. All right. So based upon the state stipulation to limit this exhibit to the 3 screenshots, I'm going to overrule or deny the motion in limine filed by Isaiah Chance. I find that the evidence the state seeks to admit that its probative value outweighs any prejudicial effect. Okay, and next would be the motions I have a copy of. Defendant Rashad Murphy's motion limine as to Robert Howard.
Judge, this is an all-encompassing motion, as the court can see, regarding several different areas. And it is buttressed on the statement provided and ultimately made confidential, made by Mr. Howard in August of 2025, as well as his deposition taken on February 4th, 2026. It seeks to limit, based on what I believe is hearsay, improper speculation by Mr. Howard, and pre-conspiratorial statements that are attributed to other defendants. Certainly understanding the court's ruling with regard to severance, I still have concerns about evidence that may in fact be admissible against one defendant and not admissible against others. As it relates to the hearsay statements, Your Honor, any statements that Mr. Howard alleges Mr. Murphy made as it relates to threats to him or his family are statements that he heard from other individuals. And that's based on his testimony at both his statement and his deposition. He talks about things allegedly stated by Mr. Murphy that were told to him by others, and goes on to suggest that in his alleged conversations with Mr. Murphy on multiple occasions, he didn't consider those conversations either threatening nor friendly. So certainly buttressing that feeling and that speculation and that statement being what he's been told by others.
Okay, so maybe it'd be helpful if we just went through these statements. You've broken out the different statements per category, right?
Yes, Judge.
So let's just start with the hearsay statements, beginning at page 2 of your motion. Specifically, you allege that Mr. Howard testified that he heard from other individuals that Murphy had made threats.
That's correct.
Okay. State, were you intending to elicit that from any Mr. Howard?
Is this as to paragraph number 5, Your Honor?
It is.
No objection as to statements he heard from other individuals, only statements that Mr. Howard heard directly from Rashad Murphy would be suffered.
Okay, so as to paragraph 5, it's granted. And then paragraph 6, Mr. Howard further clarified that he spoke with Rashad Murphy on multiple occasions. Oh, so that's
just
different.
providing
yeah.
context.
Okay. And then the next would be paragraph 7. Mr. Howard testified, subparagraph A, that he communicated with Isaiah Chance, who told him that Murphy was hot about Adam's murder. State, are you seeking to elicit this from Mr. Howard?
Yes, Your Honor. Any statements that were made by any unaffiliated party with the case, the victim, as listed in this motion, the state's not seeking to introduce. But statements made by the defendant or co-defendants in this case, the state is seeking to introduce. Not as statements of hearsay, they're not being offered for their truth, but to establish intent and premeditation and motive in this case.
Okay.
Judge, it also goes to admissibility statements as it relates to Mr. Murphy. And the argument would be it's not a co-conspirator statement based on when it is said. And in fact, I think the state would have to establish when that statement was made to determine whether or not it was in the course or in furtherance of any conspiracy. And I don't think they can do that.
So state what your argument is as far as why this is admissible if the statement was made not during the timeframes of the purported conspiracy.
Because Mr. Gonzalez's argument reverts back to a co-conspirator admission, which is a hearsay exception. The state's position is that it's not being offered as hearsay. So understanding the limitations of a co-conspirator hearsay statement, we're not offering it as a statement of hearsay in the case. It is strictly being offered as proof of other elements, so knowledge, intent, premeditation. The state has filed in its initial response to the court and had previously provided to the court the case law on this before Mr. Gonzalez's motion. So the March 5th response gave the case law for all of the reasons that the state sought to introduce each of these statements, Your Honor, and we would rely on that case law.
Okay, I'll come back.
Judge, Mr. Howard can't testify to what Mr. Chance told him about Mr. Murphy. And I don't think it's admissible based on any theory of motive.
Isn't it double hearsay?
The statements that Mr. Murphy was hot are statements that are made from Mr. Chance to Robert Howard telephonically. Is that what are these the ones you're referring to, Mr. Gonzalez?
Yes.
Okay. And so the state's not off, again, the state would just reserve the same exact basis as for why the evidence is being offered. It's not being offered for its truth. So continuing to indicate that because it's an out-of-court statement, it invokes co-conspirator hearsay when the basis for why the state is offering the item of evidence is strictly the defendant's knowledge of what was to occur, the premeditation of the act of what is to occur, because the context of that conversation is in telling the person listening, which is the witness, Mr. Howard, to be careful, essentially, when he goes to Tampa. These things are, in context, being offered for a different purpose than a hearsay or co-conspirator statement or admission.
Let me think about it. Okay, the next one, subparagraph B of 7, Howard testified that Charles Jones told him to watch out for Murphy because of Murphy's purported threats.
No objection from the state.
Okay, that one's granted. Subsection C of paragraph 7, Howard testified that he heard rumors that Murphy was riding past the prison that Howard was at.
No objection from the state.
Okay, granted as to 7C. Okay. So I think that takes care of all of the statements identified in your subsection under hearsay. Is that correct?
That's correct.
Okay, moving on to opinion, speculation, beginning at page 3, paragraph 13. Howard testified about a Bill Belichick and Tom Brady social media post, which he attributed to Isaiah Chance following the murder. Howard speculated that the post referred to Charles Jones because Brady is the GOAT of football and Charles Jones is the GOAT of rap music. State.
The witness's impression or his specific observations, I don't expect he'll be testifying about what Isaiah Chance meant, but only about what he understood the post to be.
Judge, I think that's inadmissible. It's asking Mr. Howard to speculate, give his opinion as to what he thinks something might mean.
Well, what was the
Not an
actual?
expert.
Yeah, what was the actual? What was it that was posted, and what was the content of the post?
A photograph, so it was not a part of our hearsay argument that we previously provided to the court of Bill Belichick, a coach of the New England Patriots team. There were consistent photographs of either Tom Brady or Bill Belichick posted by the defendants. Or
So Isaiah Chance posts photos of Bill Belichick and Tom Brady.
Yes.
Is there any words attached to the post or just the post?
No words on the Bill Belichick photo. I think hands up. I'm not sure how to describe the emoji, but an emoji on the photograph, but not words associated to that post. There were other Bill Belichick posts in the co-defendants' devices, so I'd have to pull them up to check for language. But to my knowledge, having discussed that with the defense attorneys, I didn't believe there was any other language that was on those photos.
And this was post murder of Charles Jones?
Correct. These were posted, some within minutes and some within the first couple of hours after the homicide.
Just for context too, Judge, some people may think Tom Brady is the GOAT of football. That's your opinion. Some people may think that Charles Jones is the GOAT of rappers, and that's somebody's opinion. And I think that that needs to be considered in its totality along with
Well,
the other arguments.
yeah, I'm just trying to figure. And so what's it relevant to?
I believe if I recall correctly, the specific testimony that was provided by that witness in trial 1 was that while he was on scene of the homicide, within minutes, he logged onto social media, saw that post, and immediately knew that the poster had done it. Like that was the testimony that was provided. There was nothing specific as to the defendant's state of mind or what the intention behind posting the photo was. It was whatever the witness had observed on scene in that moment as he was checking social media and before they were able to notify the family or the media having arrived. That was the testimony that was received, and that's what we anticipate will be the same in this trial.
Okay. So how quickly did the post happen after the homicide occurred?
I'd have to check my timeline, Judge, because there are several across all of the devices that we had received. Chance's post was on June 23rd at 6:13 a.m.
So is that the morning of the homicide?
Yes, Your Honor.
Before?
No, this is just after the homicide. So the homicide occurs about 5 a.m.
On June 23rd, so this is
Yes.
right after.
This was the,
Okay. 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 So, I'm gonna deny the motion in limine as to the social media post. However, grant it as to any speculation on the part of Mr. Howard as to what Mr. Chance meant.
Judge, although I can't be positive, I looked at Mr. Petraeus' screenshot, and it looks like the post was made on 6:13 a.m., and I think the murder occurred at 4:37 or 4:38, so it's a couple of hours,
Yeah.
hour and a half, 2 hours, somewhere in that neighborhood.
Right. So, I've denied paragraph 13 as to the post itself, but granted it as to any interpretation by Mr. Howard as to what Mr. Chance meant by it. Okay, next up, paragraph 14. Mr. Howard testified that Rashad Murphy texted him after the murder stating, "I forgive you."
And Judge, what we're talking about is not a text that the jury would be viewing. It would be Mr. Howard's testimony that Mr. Murphy texted him and said, "I forgive you," and then speculating that that is a result of Mr. Howard having been convicted of the murder of Joe Rod Adams in 2018.
Okay, State, are you going to seek to admit this?
we are seeking to admit it, Your Honor, for the same basis, the motive and intent behind the defendant having committed this crime. The testimony from Mr. Howard is that that message comes in within either the same day or the next day. I believe this is testimony at depo and trial that he receives from the defendant.
He doesn't know when he got it, really, at the end of the day. Although he does limit it to within a day or so.
Okay, I'm going to deny as to paragraph 14, but granted as to any speculation on the part of Mr. Howard. Okay, paragraph 15, Mr. Howard further testified that, is that Rashad Murphy?
Yes.
Okay, spoke with him after the murder, and that the two discussed their respective whereabouts. Mr. Howard testified that Rashad Murphy stated he was in front of Julio's car. Okay?
Yes, Judge, Mr. Howard speculated that what Mr. Murphy meant is that he was present at the shooting. But actually, Howard admitted that Murphy never stated he was present at the scene, nor that he participated in the murder, but the context of what he was alleged to have said was he was in front of Julio's car. He previously testified during his statement that in talking about the same discussion that Mr. Murphy alleged he was present at the Truth nightclub, not at the scene of the murder. And so, obviously, the inconsistencies are something that can be done in cross-examination.
Sussed out in cross-examination, yes.
But as it relates to him testifying that Mr. Murphy was in front of Julio's car, and then testifying that what Mr. Murphy meant was that he was at the murder, should be limited.
My only concern with this one is it gets a little bit convoluted. It is a part of the conversation that Mr. Howard is indicating that he's having with the defendant, whereas the defendant is completely describing the scene. You had your head on a swivel. You were looking here and there at each of the locations. And so certainly the state is seeking to admit it as identification, but I think this one, if the court is inclined as it relates to the speculation, may be one that we ask, if the court would allow, that we wait until we get to that point in the presentation of the evidence. I don't know how we can slice that up, if that makes sense, based on the context of the full statement that he gave for that.
I just don't want during the course of direct testimony for Mr. Howard
To to draw an opinion.
To speculate that what Mr. Murphy's talking about is he was in front of the car during the course of that murder.
Okay. So, again, I'll deny paragraph 14. It's admissible. But, again, Mr. Howard cannot draw opinions. He can only testify as to what was said. And then that's why we have closing arguments, and you guys can argue the meaning.
Did you say at 14, you mean 15?
I'm at 15, yeah. All right, paragraph 16, Howard also testified that Rashad Murphy later told him, "It is all good, we good now." State, are you intending to introduce that statement into evidence?
Yes, Your Honor, but no objection as to limiting without speculation on the part of the witness.
Okay, very much, very good. Then the paragraph 16 will be denied, but again, no speculation or opinion as to what Mr. Rashad Murphy meant. Okay, paragraph 17, Howard opined that social media posts referencing Don Julio were intended to disrespect toward Jones because Julio appears in Jones' Instagram handle. State, were you intending to solicit that opinion from Mr. Howard?
Not as it relates to disrespect, as it relates to Don Julio or Julio. If he has specific knowledge in this case about the fact that Julio and Don Julio are linked because of his relationship to the case, I would ask that that be admissible.
And Judge, I guess, just for clarification, Mr. Howard's not going to be testifying to his opinion that it was done in a manner of disrespect.
Right, he's just gonna say that
I saw bottles of Don Julio.
and to me, and based upon my knowledge and experience or whatever it may be, that is a reference to Charles Jones, right?
Understood.
Okay, so it's denied with that understanding. Again, as to paragraph 17, Mr. Howard can testify as to the facts or what he knows, but he can't speculate on the intention of the poster. Okay.
It's the end, Judge, of those that
Okay.
category.
Moving on to co-defendant statements.
And again, I'm going to preface before the court goes any further. Again, understanding the court has ruled
Right.
as it relates to severance. I just want the record to be very clear.
Yes, you're
Still
not-
have concerns.
Yeah, you're not waiving any objections that you've previously made. Okay, let's see. Paragraph 25, Robert Howard stated that he had multiple conversations with Isaiah Chance in which Chance expressed his dislike for Charles Jones. He emphasized that Chance and Jones engaged in multiple social media arguments in which they disrespected one another. Are you going to be attempting to admit this evidence via Mr. Howard?
Yes, Your Honor, all of it will come in through the experts, except for one interaction which occurred between Chance and Charles Jones that Mr. Howard was the primary witness to. Otherwise, law enforcement witnessed the exchanges.
And certainly my argument has to be, notwithstanding other motions and other rulings, is that Mr. Howard not testify to that if it's coming in through a gang expert.
Right.
And as it relates to his direct interaction in seeing something occur, then of course I don't have a legal objection to that.
Okay, so it's a paragraph 25, it's sort of a general argument. I'm going to deny the motion in limine as paragraph 25. However, you reserve the right to make contemporaneous objections at the time of trial. So if something's coming in through the gang expert, then at that time, if you want to raise an objection, you can, but generally speaking, it's denied. Okay, and then there's a more specific statement at paragraph 26. According to Robert Howard, Isaiah Chance allegedly stated that Charles Jones was going to die. Do you seek to admit this through Mr. Howard?
We seek to admit the conversations that occurred within the time frame of the conspiracy that's listed as it relates to these conversations, but not from before that. The motion, though, is not clear because there were conversations which occurred outside of that time frame jovial enough for them to speak often about this issue, but there are specific exchanges which occur, which indicates that there are threats on the victim's life and for Mr. Howard to kind of avoid that danger when they come to Tampa. We know that's within the time frame, regardless of whatever testimony Mr. Howard was able to give in his deposition about the specific dates, because they reference the posts that Mr. Jones made to social media of the flyers for the events that were occurring in Tampa, and that occurred on June 14th of 2024.
Judge, I would only point out that certainly we have to rely on Mr. Howard's testimony as to when he heard these things. We have no other way
I
of doing
know.
so. And to the extent that he testifies under oath that he believed that it occurred at the end of 2023 or beginning of 2024, it would have been long before any conspiratorial time frame. And again, you know, as it relates to Mr. Chance, that argument can be had in another way. So generally, it occurring within late 2023 or early 2024 is a problem. And again, I would reiterate, as it relates to evidence that a jury's going to hear that they can consider against Mr. Murphy, it's a problem.
Okay. So, well, there's two separate things going on here. So let's first discuss, if I'm hearing you correctly state, you're only intending to seek these conversations between Mr. Chance and Mr. Howard during the time frame of the conspiracy, correct?
Correct, the content of the conversations during that time frame.
Okay.
Otherwise, it is just generally the relationship between the two. Did you speak on the phone previously?
Right.
What was your relationship, but not the content?
Not the, okay, so with that understanding, that's what the state is saying. So it would appear then as to paragraph 26 and 27, because Mr. Gonzalez is alleging that Mr. Howard stated that this specific comment that Charles Jones was going to die occurred sometime at the end of 2023 or the beginning of 2024, which would be outside of your conspiracy timeframes, correct?
Agreed, Your Honor.
Okay, so as to specifically paragraph 26, that will be granted. Paragraph 28, Howard further testified that the ongoing dispute between Charles Jones and Isaiah Chance had escalated to the point that if they would have seen each other, they probably would have wanted to do something to each other. That appears to be Mr. Howard speculating. Are you going to seek to introduce that?
No, Your Honor.
Okay, so granted as to paragraph 28 is that statement. Yep.
27.
Well, 27's not, it's just a historical fact. Okay,
The finding though, Your Honor, if I may, as to 27 and 28, they really should be together, because the other remarks about Mr. Jones dying do occur within our conspiracy time frame, so I don't want the record to be unclear. There are several remarks made within our conspiracy.
right, so, okay, so as to 27, it's granted as to anything outside of the timeframes of the conspiracy, denied as to any statements made during the timeframe of the conspiracy.
And certainly, Judge, subject to later potential objections, I would certainly having no reason to dispute what Ms. Isber saying. The state's going to have to, in order to admit those statements, lay a foundation as to when
Yeah.
they occurred and whether they occurred within the conspiratorial timeframe. Anything that Mr. Howard can't tell us when it happened, if that turns out to be the case, certainly I think should be excluded.
Okay, yeah. So again, subject to contemporaneous objections at the time. But the appropriate foundation needs to be laid. Okay, paragraph 29. According to Mr. Howard, Davion Murphy confronted him regarding Howard's involvement in Adam's murder and stated, "Bro, I'm going to catch up with you. I'm going to deal with you." This allegedly occurred at least 6 years prior to the conspiracy. State, are you seeking to admit this?
We are seeking to admit it, Your Honor, for identification purposes and for motive evidence. These statements were made specifically as a part of this quote as well, following Mr. Murphy's mention that Spaz, or the person that Mr. Howard was incarcerated for killing at the time, was his relative. And so he's shouting that at Mr. Howard at the time. Mr. Howard also being present with the victim in that parking lot on this evening would be a basis as to why we're seeking to introduce this.
Okay.
It occurred allegedly 6 years prior to Mr. Jones' murder. Number one, again, just so we're clear, there is problem number one, its admission of a statement 6 years earlier and how it might affect the jury as it relates to Rashad Murphy, since we are not severed, number one. And number two, it again falls, based on the prior arguments, far outside of the conspiratorial timeframe.
All right, let me think about that one. Reserve ruling. Okay. 30 is just a statement of law, paragraph 30.
One more thing, Judge.
Sure.
Also, as it relates to the fact that there are two Murphys here, and these Murphys are cousins.
Right.
I think there's a even more complex and complicated issue in allowing that statement to come in and how the jury may perceive it, and its prejudicial effect outweighing any probative value.
Okay, thank you. I reserve ruling. 30, paragraph 31, Howard attributes several statements to co-defendant
Can we
Isaiah
talk about
Chance.
Judge?
Huh, we've already discussed it. Okay, same ruling. 32 is just a legal
Context,
argument. Okay. I think that takes care of
It
your
does,
motion. Okay, so I'm gonna think about
7A.
7A and then paragraph 29. Okay, I'll let you guys know.
Thank you, Your Honor.
Sure. And again, when we talk about the severance issue, again, just to clarify, we don't have a Bruton problem here. And then the only issue would be if there's evidence that would, quote, improperly influence, close quote, the jury, with evidence that would be admissible against one or more co-defendant and not all of them, which is kind of an amorphous standard. So it's kind of beauty in the eye of the beholder. So that would be the determination, whether that evidence would rise to the level of improperly influencing the jury.
And Judge, it goes without saying that the state would not be opposed to a limiting instruction from this court, specifically with instructions to the jury as to which defendant the evidence applies to at the time when we introduce those portions.
Sure, I understand. And it is a different, I did find really an abundance of caution, the two statements or the two text messages that the state agreed not to introduce were I think it was 2023, a set of text message exchanges between Isaiah Chance and Alicia Andrews. While those, in my opinion, are admissible as to Ms. Andrews and Mr. Chance, it does predate the conspiracy, so in abundance of caution, those should not come in. The state agreed. The other one was, I guess, the celebratory comment made by Mr. I think Davion Murphy that was sent to Sean.
Judge, I don't believe we know which Murphy
Right.
specifically sent it, but it's
Okay.
signed Murph.
Right. So for those reasons, and including the fact it was post-conspiracy and an abundance of caution, I didn't think it should come in as at a joint trial, and the state agreed. These statements that are made by the defendants during the conspiracy time frame in particular are distinguishable from those that I thought should be excluded in an abundance of caution. As I'm trying to not tiptoe close to, quote, improperly influencing, close quote, the jury, as that phrase has been utilized in specifically second DCA precedent.
Judge, and just so the record is clear, notwithstanding the court's ruling, as it relates to the celebratory messages that are not coming in, there was testimony from Detective Ramos that, in fact, the witnesses he spoke to indicated that they didn't know Rashad Murphy. It was Davion Murphy that they were aware of, and that's who they believe the text messages were sent by.
Right. So we had two issues with those messages. One, it was post-conspiracy, and two, the foundation of who actually sent it, which of the Murphys, is less than crystal clear, right? Right, okay. Okay, okay, so, and then the other motion was with regards to the Andrews verdict during penalty phase.
Yes, Mr. Harmon filed that, I believe yesterday afternoon. He is out today, but I said that I could cover it. Do you want to handle that now, or I don't know if you received it or not?
If I received it, I haven't seen a copy yet. So, do you have a copy I can look at?
Which I think I do.
Okay, thank you.
And Judge, we did briefly touch upon it. I believe that, Mr. Petratus, had filed a judicial notice of the verdict of Alicia Andrews, and we had spoken, and I think that you had previously said that obviously would not come in during the guilt phase, that it did not have a relevance. I think that Mr. Petratus had made some indication that he thought it might be relevant for penalty phase, and I think that is Mr. Harmon's objection. He filed a formal motion in limine objecting to that, as it would be improper and have no bearing or relevance to the jury's decision with regards to mitigation. It's improper character. There's no reason or way to tell this jury why
Right.
the jury in Alicia Andrews made the decision that it did. There could be numerous, a myriad of reasons, including mercy, jury nullification. We don't know why they made the decision that they did. So what happens in one defendant's trial, verdict, or sentence doesn't have a bearing, or should not have a bearing, in the current defendant's penalty phase. And so that was the basis of his motion.
Well, and it looks like there may be precedent, United States Supreme Court opinion, Lockett, right?
Yes, there was some case law that he filed as well
Okay.
in support of his position.
Okay, so I tell you what, I'm gonna take it under advisement. Let me take a look at this Lockett case, and then, Mr. Petratus, do you have any additional, or does anyone have any additional case law, or do they want a chance to submit it?
I don't have any additional case law right now.
Okay, so I tell you what, I'm gonna take it under advisement. I'm gonna look at Lockett.
Yeah, could we have a chance to?
Yep. How much time do you need?
Can I briefly address something on that?
Sure.
I just looked up the motion this morning, but I think we're just dealing with sentence, not involvement, correct? Because.
Correct.
I think that, Alicia Andrews' involvement in a penalty phase can be compared to another particular defendant's, involvement. But I'm trying to make sure that the state's motion is only dealing with sentence, not Alicia Andrews' actual involvement in this case.
Well, it says specifically in the motion, the subject matter in question is any argument comparing or regarding the verdict rendered by the jury to the Alicia Andrews case to the defendants, or otherwise arguing that fact as mitigation.
The point, exactly, the point I'm making is that I think that her involvement, any defendant's involvement, which can be a problem when you have multiple defendants, but the involvement of one defendant versus another can be relevant for a penalty phase.
Okay.
Not verdict, as in the Andrews case maybe, or the sentence, but certainly one person can be more culpable than the other. And again, the problem is suggesting that maybe one defendant should get life and another defendant should get death.
Okay, so I'm going to give you guys a chance to research the issue and submit case law, okay? So how much time do you need?
Get at least a week, Your Honor.
Sure. Okay, so I tell you what, I will give you guys until Friday, April 10th to submit any case law to me on this topic. Okay. Any other motions we need to discuss?
Your Honor, as a part of the state's response from this morning, the court had previously asked the parties to submit to the state any additional YouTube videos they intended to use or additional items of evidence that the court needed to consider, so the state did also address those things. I can tell the court that I've reviewed the videos that were provided, and the state does have some objections to those videos. I know Mr. Chance, on behalf of
Do you have them identified?
Yes, and with a link in the event that the court or the other parties wish to see them as well in the motion.
But you haven't filed a motion in limine?
I have filed a motion, yes.
You have?
Yes, Your Honor. We
Okay.
filed it this morning because we received the defense's motion in limine on their YouTube videos yesterday.
Okay. Well, can I take a look at your motion?
Yes. May I approach, Your Honor?
Sure.
Like, kind of just email me, Judge, I'm gonna print this for you.
Okay. Okay, all right, so according to this motion, the state wishes to keep out, as to Isaiah Chance, a video titled List of Dead Ops that was posted on YouTube. A block party invasion went to Young and Ace block. It's a YouTube video. 3, God Don't Know by Julio Foolio, and number 4, Demigod by Julio Foolio. So, are any of the defendants seeking to actually introduce these, and why?
These would be, these were somewhat in abundance of caution, but these would be rebuttal, depending on what is testified to by some of the state's experts, the gang experts.
I see.
And they would be authenticated through that expert, if at all. It may not be necessary depending on direct cross-examination. And possibly only if you need some still shots from some of these videos.
All right, so you're not intending to utilize these, and in your case in chief, seek to admit them in your case in chief. It would just be potentially as impeachment or rebuttal as to the testimony of the gang expert?
Correct, Your Honor, for a variety of reasons, based on gang certification and issues with Mr. Jones.
Okay, so then as to these 4 identified videos, I'm gonna grant the motion without prejudice to revisit. If you think that you actually need to introduce them, we just need to talk about it before you do it,
Yes, Your Honor, I understand.
okay? But generally speaking, the videos are not to be referenced or discussed in front of the jury until I've given permission for any party to do so. And then as to Davion Murphy, the videos listed are When I See You by Julio Foolio, again, the List of Dead Ops, YouTube video Certified Killer by Julio Foolio, and God Don't Know by Julio Foolio. And why is Mr. Murphy gonna seek to introduce these, or what are you gonna do with these?
Would be the same position as Mr. Chance, Judge, becomes.
If you think they become relevant, then you would seek to introduce them.
That's correct, could ask the court just to,
But you're not going to be submitting them as you don't anticipate at this point as part of your case in chief?
correct.
Okay, so that'll be the same ruling. Generally speaking, these videos 1 through 4, as to Davion Murphy, the state's motion is granted, however, without prejudice, to revisit, and during trial and defense, you just need to confirm with me ahead of time before you start showing them or discussing them in front of the jury.
That's fine.
Okay, very good. Then we've got unrelated officer conduct. Counsel for Davion Murphy has filed a notice of intent to rely and listed a witness and records from the Jacksonville Sheriff's Office to include the personnel history of Detective Craig Griffin and Trey McCullough. Are you gonna actually seek to utilize these records as impeachment?
Yes, Your Honor. I believe that's Ms. Tumay's motion.
She filed a motion as to these?
Yeah, I thought that was what it was correct.
Well, 'cause I don't have that motion in front of me. So did Ms. Tumay, did Davion Murphy file a motion in limine specifically to include this information?
She did not. She sent us an email with a notice of her intent to rely on the information, and she did file an amended discovery list with
Okay, so Mr. Sonardi, is Ms. Tomei, is she handling this argument, this issue?
Judge, I said I was not aware that Mr. Tomei was not gonna be here. I'm really not in a position to argue that motion.
No, I understand. I just wanna, I honestly would like to see what we're talking about here, as far as what the actual evidence is. So,
They were not filed, Your Honor, but I do have 2 copies of the investigation history. I do not have copies of the civil lawsuits that were filed against the Jacksonville Sheriff's Office for the court because they were pretty lengthy. But I can provide these copies if the court wishes.
But I don't think that was actually filed.
okay. So here's what we need to do. Are you able to contact her this morning, Mr. Sonardi?
Tried, I got her number, obviously.
Your Honor, if it's okay, I have, warrant in Polk County, if I can excuse
Yes, you're free to go. So, I tell you what, let's do this, Mr. Sonardi, let's just take a, we'll recess as far as Davion Murphy, and I'll give you a chance to, because we're gonna need to set another date, because I'm gonna need to actually physically take a look at what these records are, and, we need to have further discussion on this, and whoever needs to be able to argue the motion. So why don't you find out her availability, for the remainder of this week and Monday and Tuesday of next week, so we can get that done. Are there any other issues as to Rashad Murphy, Sean Gathright, or Isaiah Chance?
You know, Your Honor, the only thing, and this may not be the time, but I know we were talking about with the deputies, they want to talk logistics as far as how we're gonna plan on fitting everyone.
I was gonna bring that up, Judge. There's a small army on this side of the fence.
There's
Okay.
only about half of us, I think, now.
Okay, well,
You're just gonna leave that up to us and the court staff?
yes.
Do you have anything you don't want? Because
No, I really don't. As long as you guys can get to the podium without having to create a distraction, that's all I care about. So,
and certainly having ingress and egress
Yeah.
without the staff being concerned about it.
correct. So I do think, anybody that's not gonna be speaking on the record, okay? Staff that's not going to be speaking on the record, do you want them in the well, or are they okay in the audience, or what do you think?
Judge, in previous experience, I could tell the court that, for me personally, my investigator is critical.
Okay.
In a number of different ways, in a trial this big.
Okay.
So I would suggest to you that I would need my investigator at council table.
Okay, so how many people total? You have yourself, Mr. Hernandez, your investigator. Who do you need at table in addition to your client?
Mr. Hernandez, myself, and the investigator.
Okay, so you need 4 people.
Correct.
Okay, Mr. Sonardi, how many people do you need at council table?
Your Honor, obviously, myself, I'd like to have my investigator, but it's possible that she can sit behind me so that she's not at the
Okay.
table.
Could your investigator sit behind you, Mr. Gonzalez?
I'd rather not, Judge.
Okay,
I mean, unless it's a crisis situation, because he does work very closely, not only with me,
Okay.
but with Mr. Murphy.
okay, so they want,
And I would like Scotty Sonardi, the other
Yes.
attorneys with me.
and Mr. DeLauder.
I don't know.
Your Honor, I'm considering I'm the smallest fish in the pond and the last man on the totem pole, I'll go wherever I need to facilitate.
We could-
It'd be nice to be at the table,
Right.
but
If
wherever I.
need be, we can throw you off the island into the audience, right? Okay, but 5 preferably in a perfect world. Okay, Mr. Wise?
Here, we have Ms. Finkelstein, you may recall Mr. Mendez is third chair counsel as well. He's been here for some of the proceedings. And then I would like our investigator slash mitigation expert, at least during jury selection, and if there is a definitive phase.
Okay, so 5
Yes. with
people?
Mr. Gathright.
Okay, Mr. Petratus?
5, Your Honor.
5,
But we
okay,
can have at least 1 or 2 times.
yeah, okay. Okay, well, Okay. Okay, very good. So, we are,
Not very good at math, I think that's 19.
yeah, okay. That's fine. We'll figure it out. Maybe we need to change the setup as opposed to an L shape, because once we get the jury in here, it's going to be much more important that you all are facing the jury than me. So what I may do is have the bailiffs, we'll work on it, but maybe move the tables so they're actually facing the jury, and during jury selection, turn them so they're facing out towards the jury, something like that. Okay? So we'll make it work. We'll figure it out.
Your Honor?
Yep.
Hi, I'm Nixon, ICE investigator. I have Deborah, told me, she said she is available April 2nd in the afternoon at 1:30.
Okay. State.
Does that work for your Honor?
It is for me, but I don't know, does it work for the state?
Sorry, what was that?
April 2nd at 1:30?
Could we make it 2 o'clock?
Okay.
Okay, for the state.
Okay.
I will say yes on behalf of Mr. Trump.
All right. So, and then, as to,
Judge, I also think, just from speaking with Ms. Toomey myself, there's one other matter that we may not be in total agreement about, the defendant's reported statement that she may want to bring to your attention. We have worked out most of it.
as to Davion Murphy.
Yes, ma'am.
Okay. That's fine. So I will hear those matters at 2 o'clock on April the 2nd. If the other defendants wish to be present for that, you're welcome to. It's up to you. Mr. Gonzalez?
Nothing further, Judge, and thank you for the offer. I'm not sure we'll be attending, but
Yeah, that's fine. So for now, I'm going to tell the sheriff's office not to transport your client, but if something changes,
that's fine, Judge, yes.
okay, so do not transport Rashad Murphy on April 2nd in the afternoon. As to Mr. Gathright, Mr. Wise, does your client wish to be here for those motions?
I have a conflict, Your Honor. Mr. Gathright's fine with waiving.
Okay, that's very good. So do not transport Mr. Gathright. And as to Mr. Chance, Mr. Petratus?
You have to transport Mr. Chance out there.
Okay, very good. All right,
The only one that's gonna be said is
Davion Murphy. Okay? And that is so that I can hear, I know you just gave me the motion. I know you just gave it to me, now I can't find it. The motion with regards to the personnel files of two of the detectives from the Jacksonville Sheriff's Office.
And any objections from the defense if we just as a courtesy, just print out the exhibits that were provided to the state and hand deliver them to, the court at some point today? The attachments that were all sent to us with this personnel file, those lawsuits and such, everything that we attached. Is there any? Sure. Is there any objection to providing that in advance to the court for review before Thursday?
No.
Okay, and for the record, it's the state's 7th penalty phase motion for order in limine? No, that's the,
Yeah, that was the one with,
yeah, that's the one I gave you all until, gave
April 10th.
April 10th to the defense to submit any case law. Oh, okay, so it would be, we're going to, as to Davion Murphy, the motion for, it would be part of the state's motion for order in limine regarding improper character evidence as to unrelated officer conduct. That's what we will hear Thursday, April 2nd at 2 o'clock. Yeah, let's just go ahead and use in my regular courtroom for that, since it's just one of the defendants. All right, so please let Ms. Toomey know, Mr. Sonardi, that I'm gonna hear that motion in my regular courtroom. Okay? Okay. Is that it for today? Oh, and on the raw data, I need, how quickly do you think, how much time do you think you need for your experts to get that information over to the state's expert? A week? What are you asking for, state?
Judge, I think that as long as they get it to us within the week, I think that should give Mr. Harmon's experts the opportunity to be able to review it. I don't believe they have set Mr. Harmon's expert witness for deposition yet either, so I think that that's fine.
Judge, I probably should have not let Mr. Hernandez go, but, and I don't, because I don't know the status of the way that train is rolling, certainly I'm gonna just defer to whatever the court thinks.
All right, I'm gonna say by April 8th, by the time we begin jury selection, okay?
Judge, and just, that reminds me, I know that, Mr. Petridis listed an expert, a gang expert as well, that we attempted to take the deposition of, but that expert is Dr. Leap, had not actually finalized her opinion, and she said that she would have it finalized by the 8th, and we would be able to take her depo in a couple of days from that time frame. I just wanted to put that on the record, just to make sure that she has her finalized opinion by that date.
I let her know, because we scheduled it for April 9th at 5:30. And I let her know that. She responded, she's under the weather right now.
Okay.
Won't be a problem for April, but I did let her know that demo date, and she
Yep.
hasn't sent me any pushback.
So that, what's the expert's name again?
Dr. Leap.
Leap?
LEAP.
Okay, Dr. Leap's report needs to be submitted to the state by nine AM on April 8th.
I don't think she's gonna do a physical report.
Is she gonna, does she have any material she's gonna rely upon?
Yeah, she's relied upon,
The state's
the state's
evidence.
discovery.
Okay,
She will, but by the depo date, she will, when she
Okay.
gets the depo, she will have to have it.
Okay, so she's not gonna issue a report, so,
That's
but,
fine, Judge.
okay, very good.
Judge, I have a question.
Yep,
The state's motion regarding the improper character evidence.
yep.
As to Gathright,
That just says to Davion Murphy.
right, because I thought you had said it was,
Well, no, part of it was.
part of it, okay.
So I've ruled on, the motion for order in limine regarding improper character evidence and the state's response. I ruled on the video portion. Okay, that's I've ruled on. I've granted the motion without prejudice to revisit if necessary. And then unrelated officer conduct as to that part of the motion, that's being set for hearing or continued for hearing for April 2nd, okay? Okay, and I'm gonna hold on, Ms. Ismer, you gave me a copy of the state's response and motion for order in limine regarding improper character evidence. I'm just gonna hold on to that, that's okay. Okay. Anything further? Okay, so, if you don't hear further from me, or if you do need anything, by all means, make sure you contact me and let me know. I'm available to do whatever I need to do to help you guys get ready for trial. So, for those other than Mr. Davion Murphy, if you don't need me in the interim, then I will see everyone. You need to be, I would say, courtroom 1, I would be there by 8:30 in the morning. So as soon as jury services gets 175 people to walk through the door, they will send the list over to us with the names and numbers. You guys can begin filling out your seating chart, okay? So be it in courtroom
Name
1.
and number only, we're not
Only.
worried about jury sheets.
Yeah, because at least half of those people are gonna be gone by the end of the day. So there's no point reviewing juror slips for people that are gonna be discharged. There's no reason. So, and then you'll have more than sufficient time to, you'll have over the weekend to begin reviewing the slips for any and all that are coming back for phase 2 voir dire the following week. Okay?
But we'll be trying to piece in here, just jury selection. on
Correct,
one.
just jury selection in courtroom 1 because I need the lobby. Okay? Okay, very good. Thank you all.